What if the loudest story you heard was never actually written into the case? Because that's exactly what's happening here. When asked about the situation, Blake kept her words careful. She talked about fear, silence, and how difficult the past year had been. She framed it as a fight bigger than herself, about women finding the courage to speak. And that framing worked. Public opinion locked in almost instantly. But federal court doesn't run on framing, it runs on pleadings. Blake Lively filed a dramatic, media-ready complaint. It was emotional, shareable, and perfectly designed for headlines. When that alone didn't carry the case forward, her legal team pivoted. Instead of strengthening what was actually written, they began building the story around the complaint rather than inside it. Wayfarer's 15-page response cuts through all of that with one blunt message. That's not how this works. Back in December 2024, Blake sued Justin Baldoni and Wayfarer Studios, alleging sexual harassment, retaliation, and defamation. The internet picked sides immediately. Powerful man versus vulnerable actress. Abuse of power. Clear villain. Clear victim. Her lawyers went straight to the press, celebrities weighed in, and the narrative hardened before anyone asked the only question that matters in federal court. Do the allegations on the page actually support the claims? When you strip away interviews, outrage, and commentary, something uncomfortable appears. The fully formed story people reacted to doesn't actually exist in the complaint the way they think it does. And Blake's team knew it. After filing, they stopped relying on the pleading itself and started expanding elsewhere. Interviews, expert opinions, new timelines, new facts, all introduced after the lawsuit was already on file. That's not confidence. That's reinforcement. Because if the original complaint worked, it wouldn't need constant additions later. Federal court doesn't allow you to crowdsource your case after the fact. On December 12th, Wayfarer filed a reply brief on their motion for judgment on the pleadings. No theatrics, no PR language, just a methodical teardown. They reminded the court what this motion actually asks. Not who sounds more believable online. Not who won the narrative war. One narrow question only. As written, does the complaint state a valid legal claim? And that's where the cracks become impossible to ignore. Start with retaliation. Blake sued under federal and state employment laws that require one non-negotiable element, an adverse employment action. Fired, demoted, paid less, denied work, something concrete, something provable. Her complaint doesn't plead one. Wayfarer pointed this out directly. Blake's response? One sentence, no analysis, no citation to the complaint. Instead, she pointed to later filings and moved on, as if that fixed it. It doesn't. In federal court, failing to defend a claim at the pleading stage is treated as abandonment. Silence becomes concession. Then comes geography, where this case really starts sweating. Blake sued under California law, but she doesn't live in California. The film wasn't shot there. The alleged conduct didn't happen there. Key events occurred in New Jersey and New York. California law has a long-standing presumption against applying outside its borders. So Blake tried to get creative, pointing to a choice of law clause in an unexecuted agreement. Wayfarer shut that down cleanly. You can't contract your way around a statute's territorial limits. Legislatures define reach. Courts enforce it. Private contracts don't override public law. Wayfarer then walked through every supposed California connection one by one. A producer using the word birthing to describe making a film? A metaphor, not harassment. Internal HR structure decisions, not proof of a conspiracy. Complaints to Sony? Sony wasn't her employer and sent her back to Wayfarer contacts in New York. PR professionals based in California? Not employees, not decision-makers, not legally liable. Even if the court accepted every new fact Blake introduced later, none of which appear in the complaint, it still wouldn't establish jurisdiction. Vibes aren't jurisdiction. Zip codes aren't liability. Then there's joint employment. Blake spent pages arguing it. Wayfarer's response was almost dry. We didn't even raise that. But even if it mattered, the complaint still doesn't allege the required elements. No hiring authority, no firing power, no control over pay, no day-to-day supervision. Courts have rejected weaker versions of this argument for decades. Finally, defamation. Blake pointed to statements Wayfarer's lawyers made to the press. The response is fatal. Legal opinions about ongoing litigation are protected. That's litigation privilege. That's fair report doctrine. A lawyer doing their job is not defamation. And here's what Wayfarer doesn't hide. Blake's entire opposition depends on material that doesn't appear in her original complaint. By relying on outside evidence, she admits something in court she's tried to avoid admitting in public. The complaint, as written, doesn't work. Federal pleading isn't flexible. A Rule 12 motion is intentionally narrow. The court looks at the complaint, incorporated documents, and judicially noticeable facts. Nothing else. Blake had months to amend. She didn't. Instead, she asked the court to treat later filings as if they automatically updated the complaint. Courts don't do that. Ever. This case isn't about whether Blake has evidence. It's about whether she put that evidence where it legally mattered. She didn't. And that's why the case keeps getting rebuilt months later, smuggled in through briefings, hoping for an exception. Because the complaint can't stand on its own. Wayfarer asked for dismissal with prejudice. No rewrite, no second draft, no redemption arc. Not because they out-argued Blake, but because Blake never properly pleaded the case in the first place. The story sold to the public was always stronger than the story written into the law. If this helped you see the case more clearly, hit like so it reaches people still stuck in the narrative. Subscribe for updates when the next filing drops. And comment below, was this ever about the law, or was it always theater?